Mr. Howard, before you resume,
Yes,
Lord Sumption has a point he wishes to put, and which I think should be put now. I don't expect, and I don't think we expect any immediate answer, but it may be some thinking could be done about it, and you and Mr. Hapgood may have something to say about it after the short adjournment.
Certainly.
The point is this. One possible view of this case is that by choosing to apply for avoidance under Section 127, your clients may have created more difficulties for themselves than they need. The point about Section 127 is that you've got a transfer by somebody who, on the face of it, is absolutely entitled. Sickle is not party to the transfer. Sickle says, well, except that there is an additional interest, proprietary interest, other than the legal interest, which is violated by this transfer, and it must therefore be avoided. Now, that necessarily posits that there is capable of subsisting an equitable interest in addition to the legal interest, and that is the issue which we are currently arguing. It appears to be at least possible that a simpler answer to this kind of case is simply that if notice is proved against Samba, which is essential to your way of putting it as well, the result would be that there is a constructive trust of the assets as against Samba, who would be accountable on that basis. The difference between that approach and the one that you're taking being simply this, that whereas for a Section 127 application, you need to establish the existence of an equitable proprietary interest, it is sufficient to establish a constructive trust that you have notice of personal obligations of the trustee which are inconsistent with what he has actually done. And you do not therefore have to establish a proprietary right for the purpose of establishing a constructive trust. Given that you recognize that there's nothing that you can do in Saudi Arabia itself anyway, that gives you everything that you want.
Now, as I say, you don't expect immediate answer to that. It may be it needs thinking about on both sides, and it may well be that it's inappropriate for us to do anything other than to mention it. But one possibility, and the reason I'm anxious that it's mentioned to you both, is that we may mention it in the judgment, even if only to say it wasn't argued but. And we don't think it's fair to do that, or I don't think it's fair to do that without giving you both an opportunity to consider it. There it is.
Thank you. I'll certainly consider it. Let me just respond in this way.
Of course,
at this stage, not by. Because you won't be surprised to know that I don't disagree with Lord Sumption's analysis, not least because one wouldn't look a gift horse in the mouth. But
it may be a knackered horse, in which case.
I'm sorry?
It may be a knackered horse.
Yeah, well, it might.
Maybe a Timeo de Nas.
It might turn out to be, and I want to think about it.
Of course.
But assume it is a possible way, but the matter has not been argued in that way. One way of then dealing with that point, I would suggest, would be for the matter then to be remitted to the Chancellor or to the Chancery Division for that point to be dealt with.
Well, given that this is a jurisdiction hearing, procedurally that probably wouldn't be necessary, because all one would need to do is to say that there was jurisdiction.
Yes.
Anyway, no doubt you can consider what procedural steps might be necessary if the parties take this point in order to take it effectually.
Yeah. Well, I think it would go without saying, or at least I can say
You
this.
normally have to rest on the grounds on which you have argued the case, don't you? I mean, you were able to serve within the jurisdiction, so I suppose it's the other way around. You're not establishing a specific...
There's also authority, I think, rather softening that.
Yeah.
Well, we're rather jumping ahead of ourselves. I think the furthest we can probably go, if we go that far, is to mention it as a point in the judgment.
Yeah.
But it would be,
let
if
me
it's a point in your favour, which on the face of it appears to be, it would, I'd certainly take some persuading we should go any further than that, in fairness to the appellant. But let's see where we
Well,
are.
as I say, my position would be not that we should argue that point, because one would be
Well,
arguing...
you're not being invited to argue it,
No,
but
so I'd simply want... I mean, I'll come back to whether we're entitled to reserve the point, as it were.
Yep.
Can I go back to the way we are arguing the case?
That's a good idea.
Start by setting things in context, because at different points yesterday we had a discussion about what the real issue is in the appeal, and the headline issue, if I can put it like that, firstly, is as follows, which is at the date of the recognition of the Cayman Island foreign proceedings, which was the 20th of August 2009, the date of recognition is the, as it were, the guillotine point for the English court, were the disputed shares the property of Sickle for the purposes of the Insolvency Act 1986. And that's very important in this whole debate when we're talking about property or proprietary rights. It's what we're always coming back to, the definition of property in the 1986 Act. Now, my lords, we focus on the shares, and this picks up a point that was raised yesterday by my Lord Mans, because it's the shares, or more pertinently, Sickle's interest in the shares, which were disposed of. Now, the interest which Sickle claims is, we've been calling it an equitable propriety.
Now, wait a minute, you were saying it's the shares or Sickle's interest? Which do you say?
Well, it's the shares. Well, no, it's both. The point is, by disposing of the shares, we say that we owned the shares.
Yes.
But we also say, one can approach it in exactly the same way, that what was disposed of by disposing of the shares was any interest that Sickle had in the shares. It's all encompassed within the disposal. And what one's interested in is a disposition of Sickle's interest, of Sickle's property. Yes. And so we're not actually interested in the counterparty at this stage. It's the law is that you can't dispose of their interest. If I can establish that Sickle did in fact have an interest as defined in the Act, then I've got over the first hurdle, which is anything is void.
So this is assuming, effectively, that Sickle's interest was destroyed or got rid of by the sale.
Yes,
yeah.
And it, of course, if Sickle's interest persists, because it's just a personal interest against Mr. Al-Sinir, then that survives. In fact, I mean, there's an article by commenting on this case where Professor Hayton suggests that if you had a shows in action which was rendered valueless, whether that would be a disposition. Now, that's not part of our argument, and I don't actually think it's right. I think to dispose of something for the purposes of the Act, you've got to sell here the shares, or by selling the shares, dispose of Sickle's interest.
So what is your primary case then? What was disposed of under Section 127?
Yes, my lord. What was disposed? We say that we had an equitable interest in the shares, and by disposing of the shares, that equitable interest was itself disposed of. So we say both. It's sufficient for us to either look at the shares or to look at our equitable interest.
When you say the equitable interest was disposed of, are you saying it was extinguished, or that the equitable interest was transferred to Samba?
I say that you can look at it in both ways.
You can't. It must be one or the other.
Well,
you could look at it in either way, possibly.
If it was extinguished.
No, I'm sorry. Your lordship is what I mean.
You could put your case in the alternative.
That's right. That's what I meant.
In a sense, that's what Lord Sumption's way of looking at it is doing, isn't it?
Yes, and that's what that is my submission, that you either say when you sell the shares, and if Samba, as it says, is taking free and clear, then it necessarily is taking any interest of anybody in the shares.
If it's taken free of clear of the equitable interest, then the equitable interest is being extinguished because there is nobody who has equitable obligations in respect of them.
Well, then, in my submission, that what they're then getting, though, is if by you can either say, you can analyse it in two ways. They're either receiving your equitable interest and it's merging with the legal title, so it's one, or you can say that the equitable interest, leaving aside the fact that this is void, is being extinguished.
A void because of the anti-foreigners rule.
No, void because of Section 127
I see.
under English law.
Yes.
That's what I'm saying. So let's say what is happening, taking my Lord's suggestion, is just extinguishing your equitable rights
Yes.
in the shares. In my submission, that is a disposition of those shares if you of that right if by the sale.
Would it help just to ask ourselves what a disposition is in a situation where there is no doubt that you can have a division of the legal and equitable interests? In that situation, supposing the trustee simply sold to a third party, would there be a disposition? Because
Yes,
the third party could be said to take subject to the equitable interest, I suppose.
That would be the question. If he took subject to, then there wouldn't be a disposal because your interest would survive. If he took without notice, then it might destroy it, and then Section 127 might come into play. Would that be right?
Well, that's what I was going to ask.
Could we go back a stage?
Yes.
So let's take a sort of plain vanilla case in this jurisdiction where a company has appointed a trustee, perfectly normal situation, to hold shares for it. And it goes in, there's a winding up. Now, and the trustee then purports to dispose of the shares, sells them to a third party. Now,
Without notice.
let's say the third party is not on notice, so he's a bona fide, he's equities darling, a bona fide.
But wouldn't you, in that situation, be entitled to reverse the transaction simply because you hadn't agreed to any trustee other than the particular
that's
one?
the first point. It's void. It doesn't matter whether the person receiving it is bona fide.
Or is bound by the equitable interest because you're entitled to the same trustee.
Except the essence of a constructive trust is that in every case where there is a constructive trust, the constructive trustee is somebody that the beneficiary did not want to have as a trustee. Nonetheless, the constructive trust exists as a method of enforcing the trust against the person in whose hands the assets are.
That's perfectly true, and I'm not sure what that answers.
But surely it's not the only method. I mean, this would surely be a classic situation for the application of the Companies Act.
Exactly.
There would be a disposition by Mr. Al-Sanair, who's the trustee, and he had no right to dispose of it because he was a bare trustee, and he was the only trustee the beneficiary was trusting. And even if the equitable interest wasn't destroyed and there were endless constructive trusts in the hands of the third party, you would be entitled to reverse the disposition.
Exactly. You can't say that, oh, well, because the third party is now going to owe you obligations in equity, that means Section 127 hasn't been breached and it's all okay, because you've just moved from Al-Sanair as your trustee now to his accomplice, or whoever it is. It might be somebody perfectly pucker. Is just completely irrelevant, and you're entitled to say that transaction is void.
Yes, but pending your clarification of what the precise issues in this appeal are, which I think we were going to get this morning, it doesn't, because of the very limited way in which this appeal is being conducted, it doesn't matter for the purposes of Section 127 whether the equitable interest is extinguished or disposed of, because it's under Section 127, it's void.
Exactly. That's my point. I keep coming back to that the battlegrounds are very, very limited here. That what is being said is that we do not have, that the issue is, do we have an interest which is capable of amounting to property under the Insolvency Act definition? If the answer to that is yes, we win the appeal because we then go on to other issues. And what is the argument that's being run against us is that the trusts, because they are, although they're Cayman Island trusts, because the asset was situated in Saudi Arabia, it was impossible for us ever to get an equitable interest in the shares.
Proprietary interest, yes.
I'm sorry?
An equitable proprietary interest.
Well, it's an equitable interest, in fact. The terminology is slightly dangerous.
Well, nobody is saying, as I understand it, that it was impossible for you to have personal rights arising out of a trust instrument governed by the law of the Cayman Islands against the trustee. They're only saying that it was ineffective to create proprietary rights.
So the question is, where you have a trust, which the question is, what are the rights that arise out of the trust? And in our submission, the rights that arise out of it, the equitable rights, are, by their very nature, what are described as proprietary rights, in this, particularly in the narrow sense of the law of the provisions of the Insolvency Act. Can I?
Before we go on, I mean, there's a vast literature on the nature of equitable rights and equitable proprietary rights, which would probably fill this room.
And is inconclusive.
And is there any, well, you may not know it off the cuff, but is there any case which really states as clearly as is possible what the nature of an equitable proprietary right is? Because it obviously has personal characteristics rather than in rem characteristics.
Yes. What I was going to do is I wanted to look at the dicta in the West Deutsch case,
Yes.
and then I wanted to consider one or two other things about trusts, and then look at the El Ajou case.
But could I ask, with the President's permission, whether there's now an agreed statement of what the real issue is?
Well, say the issue is in the statement of facts at paragraph 16.
Yes.
That it's the present appeal is thus principally concerned with the issue of whether, as a result of the 6 transactions, trusts were created over the disputed shares, under which Sickle had an equitable proprietary interest in the disputed shares.
To my mind, the whole question is clouded by the fact that proprietary interest can mean different things, and in terms of the Insolvency Act, it is clearly defined differently from the way one would normally speak about it when one was talking about property rights.
Yes.
In terms of the Insolvency Act, it covers everything. Shows is an action, contractual rights, rights to a separate patrimony and everything else.
What it has to be, though, for the purposes of what we're talking about, is it's the word proprietary, which is in fact, as I think my Lord Collins was saying yesterday, our case is whether there was an equitable interest in the shares. And that is in fact sufficient. That is what then constitutes property in our submission for the purposes of the Act.
The way that the investigation proprietary quality comes into play ordinarily, isn't it? It is in one of two situations, an insolvency and a tracing claim. Because the trustee unquestionably owes personal obligations, and you've been taking us to various authorities saying that the nature of it is a personal obligation.
Yes.
In that situation, the precise nature of the obligation very often doesn't need further investigation. When it needs further investigation is when somebody is saying that we can actually trace through this property into the hands of somebody or other else. Because there you need something on top of a personal obligation. Yes. And the other one, of course, is the insolvency situation. And it's in those cases that one's having to look at what is the extra ingredient. Now, what is being suggested to you is that Section 217 is extremely broad.
Section 127.
127, and includes obligations and every description of interest, which would be wider than what might conventionally be described as a proprietary interest.
Yes.
The difficulty is one could, in theory, declare that the disposition of some wider interest was void without actually making it very clear what the consequences for anybody were.
Well, the question of what the consequence is not before you at the moment.
No.
That is just a product of the way Samba has chosen to, as it were, to try and cut off these proceedings. When they started, in fact, as a forum convenience challenge, saying the case should be tried in Saudi Arabia, and then an argument came in under Article 15, which is the one that we're currently dealing with, and by the time we got to the Court of Appeal, the Article 4 argument appeared. I think it appeared there for the first time. But it's and that's why the Court of Appeal say that in reality what has happened is that it's an application for strikeout or summary judgment, but it's on this very narrow point, which is simply, that is you can't get away from it. What is being said, our claim is that we have an interest which amounts to property.
Yes, well, that is what has to be determined. What
Yeah.
has to be determined in this appeal
Yeah.
is what, if any, interest Sikor did have.
Exactly.
Yeah.
And was it purely, and it comes down to, the dividing line appears to be, was it purely a personal right against Mr. Al-Sania, which therefore it would not be sufficient to create, to make the shares their property, or was it more than that, and was it what one sees referred to in the various cases as an equitable interest in the share?
But I just still don't understand that, because the definition of property is much wider than the way you've just put it, because it includes obligations and every description of interest arising out of or incidental to property.
Yes. Well, that's what I'm intending to say. I'm not sure that.
I understood you to say that it's necessary to show that the shares are property within.
No, it's the interest, that we have an interest in the shares is what we've got to show. Because it's the shares that would, if we don't have an interest...
The shares that were disposed of.
I'm sorry?
It's the shares
The
that
shares
were disposed of.
that were disposed of.
And so the only way you can set aside the disposition is to say that they were in equity or at law Sickles shares.
Exactly. And we get there.
Is that right?
Oh, no, yes.
Why is that right? Because you set aside a disposition of property. It doesn't say that the disposition of property may not be part of a larger disposition, and indeed it seems to contemplate it might be a property might include something which arises out of or is incidental to some larger
But it wasn't what
property.
they disposed of. That's the problem, isn't it?
Well, I think...
Well, it depends what you mean by disposition.
I think in a way the discussion is slightly circular. We're saying that we had an equitable interest in the shares, and by disselling the shares, our equitable interest has been disposed of.
Supposing you had a Scottish type trust, or I think it's a continental fiduciary type trust, where although there was no strict proprietary interest, nonetheless there was a duty to keep a certain patrimony separate, and claimants had specific rights against that patrimony. If an element of that patrimony were sold, wouldn't one say that, I think this is the point I'm putting you, that the rights which claimants had against that patrimony were being disposed of by being nullified, even though they were, in English eyes, perhaps only personal rights?
That's exactly what we would say. When we say that when you talk about an equitable interest, that is wide enough to encompass any rights that you have in respect of the property. And what you
That's why I think we have difficulties, because a moment ago you were saying a personal right. We were distinguishing a personal right, but that is a type of personal right.
Well, it's a personal right in respect of. I mean, I don't. I mean, I don't want to trespass on Scottish law. I don't claim to but if one thinks of a personal right, what the equitable right is, a personal right. It's called an ad rem,
yes.
And that's a personal right to require the trustee to deal with property in a particular way.
That's exactly the point I'm putting to you. Yes.
And if one thinks of, for instance, the rule in Saunders and Vautier, why is it that the beneficiaries can say, I want the property, if they all get together and say, hand it back? It's because they have that right. It's against the trustee, but it's a right ad rem to require the trustee to hand the property over to them.
That's the one thing he can't do in Saudi Arabia in favour of a foreign owner.
Well, actually, my lord, I need to correct that as a point that Mr. Hapgood has made, which is actually contrary to the way in which the case is proceeding at the moment. Because the Chancellor has found, perhaps we ought to turn it out, that the issue that he's referring to is actually in dispute. So referring to one of the share sale agreements was ignoring what the Chancellor had found on the facts. The Chancellor's judgment is in CV2 at MS 249.
Yeah, which paragraph are we looking
And
at?
it's paragraph 52, which is at page 260.
Thank you.
Sorry, that's one of the paragraphs. Yes, sorry, there's if you go back to 49,
Right.
what you can see is that there were, and if you read down to the foot of the page, that ultimately there was considerable disagreement about Saudi Arabian law. That's why the matters in the statement of facts are actually very, very narrow. The only relevant point of Saudi Arabian law, which is common ground, is that in Saudi Arabia there is there's no concept of dividing legal and equitable ownership. There's no concept of trust. Everything else in relation to Saudi Arabian law is, as it were, up for grabs and is in dispute. And so I think Mr. Hapgood, via showing the share sale agreement, was trying to suggest that there's something else which is not in issue. That's not right. Yes, it was recited as in the share sale agreement he showed you, and that's what that Sickle wasn't entitled to hold the shares. But actually, what the true position is on Saudi law and its effect is something, again, that because of the nature of the expert evidence below was left over. And one of the issues, there are a number of issues that arise. An issue, for instance, that arises is Sickle at the relevant time, although it was a Cayman Island company, was controlled by Mr. Al-Sania, who was a Saudi. So whether you would be in breach of any of these Saudi laws by, for instance, whether it could be in fact registered as the owner, bearing in mind it's ultimately controlled by Saudis was a question. Also, whether or not you could, in that situation, whether you'd be in any way breaching Saudi law by the nominee, if you like, or trusteeship, were all issues that would need to be investigated.
Well, Samba is also on the agreed facts controlled by Mr. Al-Sania.
No, Samba's not.
Samba's not?
No, Samba is an independent bank.
Oh, I see, right, okay.
No. Samba, the whole reason this litigation is taking place is Samba is a Saudi bank, but it's an international bank, has a branch in London, it's regulated in London. Because of its presence in London, this court has jurisdiction over it. And, for instance, taking your lordship's point, however we put it, whether it's a claim in restitution or a claim as constructive trustees, the reason we're able to bring it is they are in this jurisdiction, and if our rights are ultimately vindicated, then they're here and subject to the judgment and execution and so on.
The stay aspects of this are dead now. Yes.
They lost on forum non-convenience grounds. They appealed it to the Court of Appeal, then abandoned that before the Court of Appeal, not least because it was completely hopeless, because as a matter of discretion.
Well, the Chancellor stayed.
He stayed on a different point.
Yeah.
He said, because he said our claim was bound to fail because of the Macmillan point, but he said if he were wrong about that, he would have not have stayed it. He would have tried the case in England, saying that in the interest of justice, the usual test, England would be the convenient forum, not Saudi Arabia. The other side did appeal that point, but they put in a cross appeal on that point, but they abandoned it. So in form, these proceedings was a stay application. By the time we got to the Court of Appeal, it was effectively a summary judgment issue on this narrow point.
The passage you want on Saudi law is probably paragraph 45, read with the last two lines of paragraph 51. Paragraph 45 indicates that there's an arrangement called Amana,
Yes.
which seems to be very similar to the Scottish fiduciary trust.
Yeah.
And they couldn't agree whether the transactions would be interpreted as an Amana.
Yeah.
And then the judge hasn't made any findings. So it is possible you can have these sort of quasi-proprietary claims.
Yes, but none of that has been determined. And,
Yeah.
Yes. And just the point I was making about Saunders and Bourtier, of course, is that if you take this case, I think that arose in answer to Lord Sumption saying, but this is all in Saudi Arabia. But, of course, one of the things that one could have done, or at least we say we could have done, would have been to direct Mr. Al-Sanir to transfer the shares to a Saudi to whom we might sell them. So, and that's what, if there was a trust, that's what we would be entitled to do. Now, I said a moment ago, in answer to my Lord Collins, that I was going to show you the West Deutsch case. Could I do that now, which is in volume 6 at tab 64? Just before we do this, I'm going to show you West Deutsch and I'm going to show you El Ajou, but then, very importantly, I'm going to show you some more of the Travaux, because what you will see in the Travaux is it was absolutely common ground amongst everybody that a common law trust would be recognised over assets in a civil law jurisdiction. And the common lawyers were aghast. You'll see there was a suggestion at one point being made that in certain circumstances shouldn't happen, and they were absolutely aghast at that, and that got dropped. And again, that's an important part of the background of understanding the convention, but in our submission also understanding how English law or the common law operates. Tab 64, page 2994, is the West Deutsch case. I mean, the part that I'm interested in is at page 3030, where Lord Brown-Wilkinson summarises various principles of trust law.
Yes.
So in
3030.
Right.
And the first, you can see just under C, I mean, these are all very well-known principles. The first, perhaps if you'd read to yourselves C down to F.
Yes.
Sorry, could you tell me the page again?
Yes, 3030, my Lord. And as he says at just below F, these propositions are fundamental to the law of trust, and I would have thought uncontroversial. And in my submission, the point at 4, that once a trust is established, as from the date of its establishment, the beneficiary has in equity a proprietary interest in the trust property, which will be enforceable in equity against any subsequent holder, whether the original property or substitute property into which it can be traced, other than a purchaser for value of legal interest without notice. In my submission, that is the fundamental basis of the law of trust. Now,
Do you say, and this is slightly at a tangent from the point you've just been making, but it does arise out of it, do you say that for the purposes of section 127, Samba is liable to have its transaction avoided even if it was a bona fide purchaser for value without notice?
As your Lordship knows, under Section 127, there's a range of case law, and some of the cases suggest that even if you are a bona fide purchaser for value without notice, that may not be sufficient because you have to look at the interests of the creditors as a whole. Now, the reason...
Well, this may not, your answer may be, this isn't part of the present appeal.
But if the reason I'm, as it were, slightly hedging is this, that the underlying facts here were that, amongst other things, Samba was a creditor of Sickle to the extent of $60 million, which was guaranteed by Mr. Al-Sania. So that the shares, some of the shares that went to them, went to discharge the guarantee, the liability of Mr. Al-Sania under his guarantee, but also, of course, then to discharge, to that extent, the debt of Sickle to Samba. So that's a classic case where the creditor has, as it were, got a preference.
It's a preference.
And in my submission, that would be, even if they were bona fide in all of that, that would be a classic case where the court might say, well, you shouldn't be entitled to, under our pari passu principle and the principle of insolvency, to get this advantage over the other.
That's a separate basis for the right of avoidance, separate, that is, from the fact that the disposition violated the alleged equitable rights of Sickle.
Well, no, but when they seek validation, part of the issue that the court would consider at that stage is the interests of the creditors generally.
Yes.
So, in other words, my answer to your Lordship's question, if I can answer it straightly, they at least need to establish that they were bona fide purchasers for value without notice. That may not be sufficient, but they must at least establish that.
Yes. Well, I quite understand that, but because if they weren't bona fide purchasers without notice, they would take subject to the trust, irrespective of whether it was effective to create proprietary rights in. But, I mean, your submission is that we are not in the present appeal concerned with the question, obviously, whether they were or were not bona fide purchasers without notice, nor are we concerned with the question whether, as a matter of law, if they were bona fide purchasers without notice, that would be a defence to a suggestion that the transaction should be avoided. That is a question on which there is inconsistent authority and is for another occasion.
Yes, exactly.
Right.
That's why I'm very concerned that we recognise there are... I can quite understand, your Lordships all think it's a bit odd that we're looking at it in such a narrow way, But
I'm simply trying to work out what the forbidden territory is.
yeah, no, but I understand that, and the territory is. I'm sorry, I keep coming back to it, but it is: do we have an interest which in the shares, which would be property for the purposes of the Act? Now. One of the things that we say, sorry, to turn my back on you. One of the things that we say is that, by way of an example, is imagine the situation where Sickle learns that Mr. Al-Sinir is about to make a transfer to a third party in breach of trust. We say we would have been entitled in that situation to go to the court in the Cayman Islands, or possibly the court in London, because of if that could have jurisdiction, restraining him from undertaking the transfer of the trust property. That is to specifically enforce his obligation in respect of the trust property. And we would also be entitled to get a similar order against a third party who is intending to take the trust property.
And on that footing, he'd have notice anyway.
Well, that's right. But got to remember, the argument that's being made against us is that it doesn't matter if they have notice. That's actually the critical issue. You have to assume for these purposes, I mean, Samba no doubt will say in due course we were perfectly innocent. But to test the legal proposition, you have got to assume that they know full well what the position is.
Yes.
Now, my Lords, can we then go to, I want to quickly look at Webb and Webb, which is in A6 again. Just this is another illustration, but it's quite helpful in relation to foreign property. Here, a French apartment. That's at tab 63.
Yeah.
Page 2, MS 2983.
Yep.
And if you can see in the headnote that the defendant, page 2983, purchased an apartment in the south of France in his own name. The plaintiff, his father, claimed it was purchased as a holiday home for himself and his wife, with funds provided by him, and that by virtue of an express agreement, the defendant held the property on trust for him. And so that's what he was seeking to enforce, that trust over a property in France.
Yep.
And if you go to page 2991, sorry, it's in the judgment of Judge Baker, you see. Just below F, the plaintiff in the present case doesn't rely on any contract for sale. He relies on a fiduciary relationship between him and the defendant, who he says is his trustee. This is one of the foundations of equitable jurisdiction. And here again, the main method of enforcement is an order in personam against the defendant. He can be required to execute the trust by transfers or rendering accounts. The relief claim doesn't include any form of vesting order or an order directing the rectification of some register of title, or even a declaration that the plaintiff is the legal owner of the property. What the plaintiff claims is a declaration the defendant holds the property and its contents on an express or resulting trust, and in order to execute such deeds and documents as are required. Then there's an alternative claim for a declaration of tracing. And if you go to the next page at 2992, just below E, the orders sought in the present case do not seek to disturb the title of the defendant otherwise than by his own act. Now, that's an important point in relation to Mr. Hapgood's submission, that somehow we are interfering in this case with Saudi Arabian law of property. We are not seeking to disturb the title.
That's the legal title.
Yes, exactly. And so, accordingly, in my judgment, the proceedings do not have their object rights in rem. They have as their object the establishment of the defendant's accountability as a trustee for the plaintiff. Now, of course, that's the party with whom you're in a direct relationship. Here, ours is, our case is that we have a statutory cause of action against Samba.
And the Webb and Webb case in the European Court says something similar, doesn't it? It says English equitable rights are not rights in rem.
Yes. And
Well, is that right? That they're not rights in rem?
well, that goes back to this debate that I think we've all been having: is what do you mean by proprietary
Yeah.
rights? And one can see that in a civil law country, I mean, perhaps we're having enough difficulty grasping the concept, so civil lawyers may have more. That it's not a conventional property right as it is when you're talking about title, because it's something that doesn't appear on the title. It's something
Specifically doesn't, exactly.
It's
It
a
would-
right to require the trustee to treat you as if you were the owner.
Yes.
Exactly.
I mean, the irony is that equity makes a great song and dance about applying in personam, and yet it's proprietary, give proprietary rights. It's almost a contradiction in terms.
I mean, the test is whether it's assertable against a third party.
Exactly.
Which is the whole point about the law relating to notice.
Yes, exactly.
yes. No, of
Is
course.
that, is that the sole test? Because there can be personal rights which are enforceable, a few of them against third parties. The Lord Strathcona seems to come to mind.
I'm not.
The Charter Party
Oh,
case.
right.
Comes to your mind.
Anyway, I mean, it's...
Well, there may be some
and the
personal
Scottish-
rights.
And the Scottish Fiduciary Trust seems to operate on that basis.
One way some of the academics have analysed this as to what it is one is talking about is that it gives you a negative right, i.e. a right to exclude other people from the property. Now, what I don't want to do is get too heavily involved in an academic debate, because in my submission, if one asks oneself the question, because there's a danger we move away from actually what the question is here. There was a Cayman Island, it's accepted for present purposes as a Cayman Island law trust. So under that trust, there isn't any question that you got an equitable interest in the shares. That's the whole nature of it.
And there isn't any question that that was the object. Whether it was achievable in relation to Saudi assets is very much in dispute.
Yes, that I follow. But if one if you have a Cayman Islands trust, that would be its effect if it takes effect.
If it's effective, that's what the parties intended to do.
That's right.
Yeah.
Is a contractual right within the expression property in Section 436 of the Insolvency Act?
Is a contractual right?
Yes.
Yes. But the difficulty is, you've got to remember that Section 4, you have to then consider whether under Section 127 there's been a disposition.
Exactly.
And so you could argue, I mean, Professor Hayton suggests in his article about this very case that the disposal of the shares could somehow be a disposal of a shows in action that you had against Mr. Alcinier. Now,
As trustee, that's quite a difficult proposition.
that's why we're not pursuing it
Well, I'm
that
not
way.
surprised.
At least it wasn't a point that commended itself to anybody on our side when
Very understandable.
preparing the case. And so that's why we're saying, why we come back to the interest in the shares. Can I go to...
Where is that article?
I'm going to show it to you in a moment. I've got the reference, but because I want to look at it for another purpose, but you'll see he says that. The Elajou case is in volume 4 at tab 31 and MS page 2201.
But forgive me, if you have contractual rights in relation to shares, which depreciate the value of the shares in the hands of the legal owner, and he disposes of the shares in such a way it destroys those rights, if those contractual rights are property, why isn't it, bearing in mind the purpose of Section 127, capable of being within the concept of disposition of the company's property?
That's I mean, that's certainly what Professor Hayton is.
I know, but why isn't it? Because
Well, I think the answer would be that your contractual right against Mr. Al-Sania remains. The reason it's not a valuable contractual right is because he may not be within the jurisdiction or he doesn't have any money, but you still have your right. It's become actually a secondary.
Your right against him has not been extinguished,
No.
nor has it been transferred to Samba.
No, it's become a secondary right probably to claim damages.
as your right as a beneficiary would be against the trustee who disposes of your property, that you still have a claim against him.
Well, but you lost your
Yeah.
property.
You might be able to assert it against somebody else if he had notice and was a constructive trustee. It all fits together perfectly on that assumption.
Well,
And if there was notice, I think you reserve the possibility that that's the basis on which you would succeed.
yes, but we say it arises, I mean, as well as the way the suggested constructive trusteeship, it arises in the same way through Section 127. Then in fact, it's getting to the same point.
If he has breached a personal obligation, may he not be amenable to the court's jurisdiction to unwind that which he has done?
We've got to remember, Mr. Al-Sania is not before the court.
Yeah.
So it's Samba who are before the
But
court.
you're arguing about, you stressed yesterday, about
Yes.
the position between yourself and Mr. Al-Sania.
No, well, I was giving that as an example.
So we have to focus on that,
Yeah.
you said only.
No, when
Yeah, I
it,
suppose
yes,
before the Cayman court in a liquidation action.
I'm sorry, I didn't catch that.
If in proceedings in the Cayman Islands under the liquidation, Mr. Al-Sania might be amenable to the jurisdiction of the Court of Liquidation. Might he not?
Might, but
That's very enthusiastic, Mike.
you mean,
Where he would
by-
be a person affected by a liquidator's summons to determine the interests in the relevant assets and capable of therefore of being served, would he not?
Well, I'm just not sure. I mean, he might in theory, whether in practice.
He might default, I quite agree.
Bearing in mind, it seems that he's defrauded various people. It's pretty unlikely he's going to, in fact, turn up in the Cayman Islands.
You're allowed to pursue these proceedings, are you, without joining him?
Yes.
Setting aside a disposition which he made.
Yes, we don't have to join him because what we're saying is that the disposition of the property was void. Any disposition is void, and so we then are entitled to say to somebody who has received our property, you shouldn't have received it, and they are accountable to us.
But it's a slightly odd concept, isn't it? Setting aside a transaction between a person who is not before the court and a person who may, we do not know, be a bona fide purchaser for value without notice. This seems a rather striking exercise of the reach of equitable power.
Well, the reach here is by virtue of the Insolvency Act. It's nothing to do with equitable power, with respect. With respect, this case,
You had to serve, did you, in the normal way on Mr. Samba? So I suppose you could join Mr. Al-Sania as necessary or proper party.
You don't need to because this section says it's void.
Yes,
It's not a setting aside
no,
situation.
the transaction. The transaction is void. The proceedings here have been commenced against Samba.
Well, I understand that.
But
Just I share Lord Sumption's view that it seems slightly odd that you can even assert that the transaction to which somebody who's not before the court is void. So there why you say you can do it and it hasn't been raised.
yes, but I mean, it's certainly not. It's not relevant to the issue that we're considering.
None of the Section 127 issues are actually before us on this appeal, are they?
No, the only issue is, well, the issue is only before you in the sense that it said you can't have a Section 1, your claim cannot get off the ground because you didn't have any property within the Act.
Yes, so the question is simply, is there property within the Act? What effect that has on Section 127 or on any other rights that may subsist as between Sickle and Samba is for another occasion.
Precisely so.
You're going to show us El Arjou one?
Yes. Now, in this case, you'll remember that what was happening was that the plaintiff was asking the English court to recognise that they had at the relevant time an equitable interest in the proceeds of a fraud under a trust. The court held that the plaintiffs and other victims of the fraud had a recognisable equitable interest, and that's at page 2218 at D, where Mr. Justice Millett, as he then was, said, but if the other victims of the fraud can trace their money in equity, it must be because they've been induced to purchase the shares by false and fraudulent misrepresentations. They're entitled to rescind and revest the equitable title to the purchase money in themselves, at least to the extent necessary to support an equitable tracing claim.
So which page is this? I beg your pardon.
That's at page 2218.
Thank you so much.
At D.
Thank you. Yep.
And at E to F, well, you'll also see how he explains how you can get the assistance of equity to follow property of which you are the equitable owner. And he explains it's not some new model remedial constructive trust, but an old-fashioned institutional resulting trust. And then at 2220 is a passage that I rely on under the heading Tracing Through Civil Jurisdictions.
Yeah.
And
Oh, yes.
you can see that counsel for DLH submitted that the plaintiff's claim, whether personal or proprietary, depends on the continuing subsistence of his equitable title to the money and cannot be established where the money had passed through the hands of recipients in civil law jurisdictions which don't recognise the concept of equitable ownership.
Then we can pass over the next few.
Gloss over the next bit. And
But
pick up-
even if the argument.
Yeah, that's what, and perhaps if your lordships would prefer, if you read from G and then to the bottom of page 2221.
Right. Seems to be exactly the point you're making. There's a certain resonance with what Lord Sumption was putting to you and Mr. Hapgood first thing. Yeah. But I see how you say it helps you. But then we have to bear in mind what the same judge said about this in Bishopsgate.
In Macmillan, yes. Well, in my submission, I'll have
Sorry, I haven't finished reading it.
I'm sorry.
My fault. Of course, he ends up in the last paragraph referring to this being a case where the assets end up in the legal ownership of a defendant within the jurisdiction,
yes,
just by letter J.
yes, but the The critical point is, of course, because you've got, and that's what it comes back to, if you can establish an equity, then providing you have in personam jurisdiction over somebody, then you can enforce it. And so the assets go through here the civil jurisdictions, and that doesn't create any problem for the tracing, because once they are back in a common law jurisdiction and the defendant is in the jurisdiction or amenable to the jurisdiction. I mean, the paragraph at H, an English court of equity will compel a defendant who's within the jurisdiction to treat assets in his hand as trust assets if, having regard to their history and his state of knowledge, it would be unconscionable for him to treat them as his own. Now, of course, that entirely resonates with, as it were, the constructive trust analysis that Lord Sumption was put forward, but it also entirely resonates with our submission, which is that we had an equitable interest in the first place, and we can make a claim against Samba, or we actually are making the claim not purely to enforce the trust. We just have to prove we had the proprietary interest and then say the transaction was void, and you got a hand.
What is void? What aspect of it? Because unless there's some special construction of Section 127, an English court can't declare a transfer of Saudi shares to be void unless it's void under Saudi law.
Well, what it can do is, again, it can't affect the position in Saudi Arabia.
Now, I'm not talking about proceedings, I'm talking about construction.
Well, what it, as a matter of English law, it says is that the transaction was, as a matter of English law, void, and it then gives...
Including the transfer of legal title?
Yes, because what it is saying is then... I mean, if it, say one had a situation where undoubtedly the shares were owned by everything. Sickle was the legal owner in Saudi Arabia, and Samba acquired them in Saudi Arabia. The English court would declare that that transaction under the Insolvency Act was void, and it wouldn't be concerned with whether actually under Saudi Arabian law, there may be some peculiarity, let's say, where something hadn't been registered properly or whatever it was, that whether or not it was or wasn't valid. Otherwise, you could always escape Section 127 with assets in a foreign jurisdiction, saying, well, it's not for you, English court, it's a question for the foreign court. And it's where the foreign law will become relevant is, and that's what the Court of Appeal say here, when you're considering at the validation stage, you consider, well, what actually the law is in Saudi Arabia and what effect it has and so on.
But the point that Mr. Justice Millett is making in El Adju, as he explains in Macmillan and Bishopsgate, is that the basis on which the court is enforcing the trust against a person within its jurisdiction is that it is sufficient basis, it's sufficient to justify that there is a personal right. And that was something that he was in a position to decide because, as he points out in Macmillan, this was not concerned with title, but simply with personal obligations.
Well, it's concerned with personal obligations which give rise to equitable interests. And the whole premise...
It wasn't with the proprietary interest that this analysis was concerned, as Mr. Justice Millett explained in Macmillan and Bishopsgate.
Well, in Macmillan and... in the Macmillan case, which you've got loose, I'm not sure where it was handed up to you yesterday. What he said was that El Adju, it's at page 989 to 990, and at page 990, letter B, he said that the case was concerned with tracing, not title. And
Yes.
that's entirely right. But our case is not concerned with title. We're not saying we had legal title to the shares. We're claiming we had an equitable interest in the shares. In my submission, there's nothing that Mr. Justice Millett is saying in Macmillan and Bishopsgate, which is inconsistent with our case or with what he said in El Ajou. And can I show you, you will see in El Ajou, he refers to the Cook Industries case, because that in our submission is a helpful case to look at in relation to this. Can we hand that up?
Well, I mean, just to pick up your point, I haven't got my mind completely around what the point in Macmillan was, but he explains in some detail what he held in that passage in Macmillan. He explains in some detail what he was concerned with in El Ajou, but then between C and D on page 990, he said the present is the converse case. It's concerned with title, not tracing. There's no doubt that the Bellit shares in which the defendants claim security interests are the self-same shares.
Yes.
That looks as if he's saying, as I say, I haven't got my mind completely around it, but it looks as if he's saying this is a case concerned with equitable interest, not tracing.
You have to remember what...
And it might be said against you that this case is concerned with equitable interest, not tracing.
You have to remember what was the issue in Macmillan, what actually the battle was about, was which law did you apply as to the question whether or not somebody was a bona fide purchaser for value without notice. That was actually the question, and whether you applied New York law or English law.
Yes.
And that, in other words, whose law is to notice, I think, was what was critical. So that's, as it were, you've got a claim to, that's why it's quite different to what we're debating. You've got a claim in Macmillan between competing interests.
Yes.
So you've got two parties who say, I'm entitled to these shares.
Yes.
And you're having to decide which law, you're having to decide, how did you decide who had the better title?
Yes.
Our case is not at this stage about competing interests. It is about whether, as a matter of English law, or Cayman Islands law, we ever did in fact create an equitable interest in the shares.
Yes, so this is on your extremely limited
Yes.
basis, so that we're not even concerned with the position of Samba at all.
No, you're not.
And so we just go back to Westdeutsche and you say that's the end of the case.
I do. That's...
Well,
I mean, it's because of the way the argument has been run. I mean, one could understand, Samba could have been running a different point to say, well, because I've acquired title in Saudi Arabia, that might be a complete knockout blow for you. And then there'd be a different argument. We haven't got to that. They, for whatever reason, didn't think that was the point to run. They've run this just narrower point, or antecedent point, and narrow point.
Yes.
The other case I wanted to show you was the Cook Industries case, which is referred to, if I could just I think, has that been handed up to your lordships? This was a case where, as you can see from the head note, you had an American corporation who were assignees of an unsatisfied judgment debt for $2.5 million, resulting from a trial in New York concerning fraud and manipulation of shares. And they suspected that the judgment debtor had transferred valuable works of art and furniture from his New York flat to a Paris flat. The lease of the flat was in the name of his friend, but the rent was paid by a company controlled by the debtor. The corporation issued a writ against the debtor and his friend, claiming a declaration the lease of the flat and its contents were held on trust. Alternatively, a declaration that the transfer of assets by the debtor to the friend was made by was a conveyance to defeat and delay his creditors. And it was held on the next page, first holding, that the court had jurisdiction to entertain an action for the determination of the title or right to possession of any immovable property situated out of England where there was an equity between the parties, that there was clearly an equity between the corporation and the debtor, and so on. And if you go to page 441 at G, you can see that the counsel, Mr. John Weeks for the friend, just below G, argued there was no direct equity between the company, the corporation, and the friend. And if you go on to page 443, at letter E,
Yes.
where His Lordship, Miss Justice Templeman, says that the plaintiffs are not the original judgment creditors. They're assignees, but that doesn't make any difference. As assignees, they have all the rights of the original creditor. Secondly, he says, as his counsel, there's no equity, direct equity between the plaintiffs and Mr. Gallagher, whatever the position may be between the plaintiffs and Mr. Sarley. There must be, he says, some personal equity running from the plaintiffs to the defendant, citing Dicey. And then he says, it seems to me that if the plaintiffs are right, there is a personal equity. It's a personal equity between the plaintiffs and Mr. Sarley, who's taken steps to defraud them of the benefit of the judgment debt, taken steps to hide his property, which ought to be made available to the plaintiffs, and ought to be there for the plaintiffs to impose a charging order and to get an order for sale and satisfy their debt. Similarly, it seems to me, as I say, I make no finding on it, I cannot at the moment. Mr. Gallagher has lent himself to assist Mr. Sarley in a campaign ensuring that Mr. Sarley's assets don't become available to satisfy the debt. It'd be monstrous if equity turned its head and said there's no relationship between the plaintiffs and Gallagher. Accordingly, it seems to me there is jurisdiction to bring this action as regards the ownership of the flat. And at the top of the next page, at letter A, he said he took the view there is jurisdiction to make an order about the flat for inspection, jurisdiction to make an order as regards the chattels. And that, in my submission, is a case where you have, well, self-evidently, you have property which is in a civil law jurisdiction where the English court is recognising an equity and saying it has jurisdiction to enforce that. In other words, it recognised an equitable interest in an asset situated in a foreign jurisdiction. Now, my lords, can I then, having looked at those English authorities, which in my submission show very clearly that an English court of equity will recognise a trust and enforce a trust over assets situated in a civil law jurisdiction, what I'd like to do is to look at next, because one needs to come to the arguments under the Convention, to look at the role and purpose of the Convention. And can I ask you, for this purpose, I hope I'm not being tiresome, to look again at the travaux, because they are instructive. So I want to look at volume 2 at page 1400. When I'm showing you a number of passages, you need to keep in mind the argument that has been made by reference to Article 4 to try and actually understand what it is that Samba is saying. Because, of course, it's quite easy to get slightly confused. There is an argument or an issue as to the extent to which Article 4, which plainly applies to as it were, the plain vanilla situation where the settlor sets up a trust by passing property to a trustee to hold on trust. So you can see that Article 4 is plainly at least directed to the question of the transfer to the trustee and saying that falls outside the Convention. There was then a debate about the extent to which issues that can arise, if I can put it like that, in relation to a declaration should fall outside. But what no one was suggesting, this is absolutely fundamental, no one was suggesting that you could not, for the purposes of the convention, have a trust, a common law trust, over assets situated in a civil law jurisdiction, and that it would be of the essence to first decide whether the civil law jurisdiction had this concept in its law, the law of the lex situs. Not only is that not said, the opposite is said, so that it would be really quite remarkable if one now concluded.
Yes, there's a lot of talk about whether declarations of trust came within Articles 2 and 4, but no discussion of what the consequence of that.
But what the context, and Mr. Green, when he got to that, rather skipped over it. The issue that they were concerned about, the only ones anybody talked about were what's called formality, I'm not sure what that issue would be, and capacity. And that's what the civil lawyers were concerned about. No one was saying, well, there's an issue where you have a declaration of trust, or indeed where you set up a trust at all over an asset in a civil law jurisdiction, as to whether the civil law jurisdiction has this in its armoury.
But why does this matter? Because on both competing arguments, Article 4 is about the validity of something. In this case, it would only be relevant if it was suggested that the trust created under Cayman Islands law, as we must assume, was invalid. But it's not. It can't be invalid. It's perfectly valid. It creates personal obligations. It's valid by the law under which it was created. The real point taken against it is not that it's invalid, but that it's ineffective to create a properly so-called proprietary right in respect of an asset in Saudi Arabia. That's not a validity point at all.
Well, no. I agree with you, but that the argument that's being made against us is that one has to remember that what are the steps in the argument. Mm-hmm. If the convention applies to the question of validity, which we say it does, then that is a question of the law of the trust, which is Cayman Island law. Therefore, questions of Saudi law simply don't arise if you're asking, was a valid trust created? So Samba seeks to get out of that difficulty by two steps. Step one is, they say, that questions about essential validity, whatever that may mean, something that goes to the question whether you can, I think, set up a trust at all, is not within the convention, they say. That's taken outside by Article 4. That's the first step of their argument. That then takes them into the common law, and then their argument is the common law, conflict of law rule, takes you to Saudi law. That's their lex situs.
Well, they can only say that in respect of the proprietary interest. Right. If you validly, under the law of your choice, purport to create something that brings into existence both proprietary and personal obligations, the next question is it effective as regards particular assets? And it may be that the answer to that question is no if the assets are in Saudi Arabia, but that's not a point which is concerned with validity at all.
No, exactly. That's a different point.
But it's the only point.
No, my Lord, if one, maybe I'm misunderstanding the Lordship's point. If one says, was this effective? That's, in other words, could you go to Saudi Arabia and give effect to this? The answer to that may be it wouldn't, because the Saudi Arabian court may not recognise this, because it's not party to the convention.
Right.
But we're not in, and we've got no intention of going into the Saudi Arabian court.
Yes.
But also, on your very narrow basis on the appeal, you don't have to concern yourself on your case with anything about other than the consequences and inequity of the Declaration of Trust.
Yes.
Which is called proprietary in English law.
Yeah, but that is actually our case. That's right. Looking at Article 4, I'm really addressing the argument that's being made against me, which, as I say, as I understand it, that they try to use Article 4 to say that the law of the trust doesn't matter. That's what they're trying to do, to sidestep the convention, to say, I can go back to a so-called English common law conflict.
But the whole premise of this argument is that if you go back to the common law, you end up with Saudi Arabia.
Yes.
And the validity of the trust can't possibly be governed by Saudi Arabian law, even if Saudi Arabian law may be relevant to show that the trust won't work in relation to Saudi Arabian assets.
Yes, my lord, we agree with all that. That's why we say this is all a nonsense.
Well, quite.
But what I wanted to show you is that there's a sort of...
It's nonsense on its own terms as well as globally.
Exactly. And what I wanted to show you was globally that this is entirely inconsistent with the convention and what everybody was talking about at the time. Then it's inconsistent on its own terms with Article 4, and I'll have to show you Article 15. But, I mean, of course, none of this arises in any event. It's all moot if you agree with me on the first point, that there isn't a conflicts of law provision in this jurisdiction, which, as it were, mandates Saudi law to apply to the question as to whether or not an equitable interest in the shares was created by reason of their being in Saudi Arabia.
Either under the convention or common law.
Yeah, if it's because I win because that Mr. Hapgood's argument is predicated upon his being able to point to a common law conflicts rule which says Saudi Arabian law trumps the Cayman Island Trust. That's what it amounts to. If there is no English conflicts of law rule which does that, then the debate about the convention is interesting but irrelevant, or one might just say irrelevant, depending on your appetite for these
No,
things.
it's actually quite interesting too, like most irrelevant things.
But I'll try and take it with that.
So you say ultimately the issue of principle that's raised in this case is whether the common law rule that lex situs governs everything is sufficient to produce the result that any trust argument that you raise in respect of shares, which for this purpose are assumed to be cited in Saudi Arabia, is invalid or not.
That in truth is the...
You say that's cut to its chase is the issue.
That's what it all comes down to. And unless, as the Chancellor found, unless, as it were, Millen is the trump card, which means that you cannot have a trust which creates an equitable interest in an asset in a civil law jurisdiction, which doesn't know the concept. Unless
That's trespassing into effectiveness and away from validity.
Correct, but it has to be that the trust is invalid. That the trust is nihil ad rem. That's really what it amounts to. It just doesn't exist for these purposes.
Well, those are two different things. The trust may be irrelevant or it may be void. The one doesn't
No,
lead
but
to the other.
But the effect of what the Chancellor has said is it just doesn't come into the picture.
But this convention covers lots of trusts which are non-proprietary in the English sense, so which are just fiduciary.
It does.
And they would operate perfectly well in relation to Saudi Arabian shares.
But the whole, if one has to step back and ask, what was the purpose of the convention? What was the fundamental purpose? What were they all talking about? The fundamental purpose was this concern about non-trust states recognizing common law trusts which were in their states if they became a signatory. But it was a given that a common law state would recognize and enforce a trust over an asset in a civil law state.
Oh, your analysis, there are two curiosities about looking at the convention at all. The first is that we are concerned with what we do as a common country, not what Saudi Arabia would do. And secondly, if Saudi Arabia is relevant, it isn't a signatory to the convention.
No.
Like so many areas, it seems to me that the answer to what you end up with depends on what is your starting point.
Well, I agree with that.
Because we all know that absence, apart from certain cases of constructive trusteeship with which we're not concerned, you can't have a trust without trust property. You take the starting point. You look at the creation of a trust. You say, well, the trust is arguably governed by Cayman law. And if you look at the authorities you were taking us to yesterday, Marlborough, etc., of course you can have, a trust can have property in any place in the world. They start by looking at the property and saying, what governs what conflict of law rule governs title to property? Macmillan lex situs. Therefore, there was no property, which can't therefore have been trust assets because of the conflict rules relating to title. So depending on whether you start by looking at the property or start by looking at the creation of trust, each side ends up with the position with the answer that it desires. The problem is that you can't have one without the other, and I find it difficult to find at the moment a clear principle basis for knowing with which of the two one should start.
Well, in my submission, the answer is actually as follows, that there is no question in this case that Mr. Al-Sania had title to the property. In other words, one could have a situation where there's a question, did he own the shares in the first place?
No, that's a given in this case.
Yeah.
At least everyone agrees on that so far.
I'm saying, so that questions of title in our submission simply don't arise. You're never concerned with the Macmillan question. The conflicts issue one is concerned with is just a different one, which is the conflicts questions as to whether or not English law gives effect to a trust, a foreign trust. Here, a Cayman Islands trust. And it's not the conflicts rules relating to the law of property, it's the conflicts rules relating to the law of trust.
My fault, but I'm still not getting, in my own mind, a clear answer to my question, why should we start where you start and not start where they start?
Because I'm not seeking to enforce I'm not making a claim to title. I'm not seeking to enforce a claim to title. If I was saying I am the legal owner of the shares, not you, Samba, then one could see if that was the battle, then the rule in Macmillan would be relevant.
But you are saying your whole point is you are saying you had a proprietary interest in these shares which has been disposed of.
Yes. But what I'm saying is, you've got to remember, the relevant point at which you're asking whether I had an interest is before Samba are even on the scene. They're not even there. It's in August 2009. They don't appear until September 2009. The question is, when the winding up moment occurred, did my client, Sickle, have were the shares, or did they have an equitable interest in the shares such that to amount to property for the purposes of the Insolvency Act?
All right. Well, anyway, you were about to try and take us to something in the Travers some time ago.
I was.
Although you say it's all irrelevant.
But just to clarify that point, you're saying that both at common law and under the Convention, the validity of a declaration of trust is governed by Cayman law.
Yes.
And then one of the incidents of Cayman law is that you have an equitable proprietary interest irrespective of the lex situs.
Exactly. So that's the beginning and end of the point. And I say, not only is that there's nothing in the Convention to say that's wrong, it's entirely to the opposite effect. Can I just firstly show you some references to the early discussions in Volume 2 at MS page 1400. And in the right-hand column, this is part of the preliminary discussions, you can see the Commission considered that trusts created under the laws of Anglo-American jurisdictions for family, business, financial and other purposes increasingly present connecting factors with civil law countries where the trust is generally not known, while in some instances a trust may more or less readily be adapted to a legal institution of the civil law. By and large, the existing legal situation is not satisfactory and gives rise to numerous legal and practical problems. It's often highly uncertain what effects, if any, will be given to a trust in a civil law country, whether it will be held valid there, and as a result, sometimes legitimate interests of parties to a trust have been frustrated by application of inapt rules. And then they said that they should seek a solution through an international convention. And at page 1495,
Yep.
so perhaps if you go to 1493,
Yep.
Mr. Bennett, who you met yesterday, who's
Yes.
in the left-hand side of Australia, he emphasised that the task undertaken by the conference in drawing up this convention was an ambitious one, since the trust was unknown to civil law countries. Nevertheless, the need for such a convention was certain. When trust property is situated in civil law countries, the trust should be recognised as such by their courts. The objective of the draft was a desirable one, and the preliminary draft was generally satisfactory.
Sorry, I'm missing which page, forgive me.
Sorry, I'm sorry, my lord. Page 1493.
Thank you very much.
Left-hand column, Mr. Bennett.
Yep,
And then I wanted to look at the right-hand column, Mr. Waters of Canada.
thank you.
And about 4 lines down.
Yeah.
He says, the main justification of a convention on the law applicable and on the recognition of trust was that it would eliminate uncertainty, for example, in cases where trust property was held in non-trust jurisdictions. And Professor Hayton, 2 pages later, at 1495,
Yeah.
reverts to the theme in the bottom right-hand corner, 5 lines up from the bottom. There was a real need for such a convention, as there were many trust assets in civil law countries. It was also clear that the trustees would be more ready to invest in a country if there was reasonable certainty the trust would be recognised as such. And so the UK was happy with the convention.
How does this work if you're not talking about a convention country where the assets are held?
No,
How useful is the convention in that context?
well,
That seems
it's
to be-
what was hoped was, I mean, there's actually only been half a dozen countries sign up to it or so. So obviously what was hoped was that you were going to get much greater,
Yes.
So we're, in our case, the only relevance of all of this, of course, is that we're in England, obviously, and the convention is now part of English law, except for Article 13, which I'm going to come to in a moment, which is actually important in relation to this debate. But it's all I'm referring to this is to show you that what everybody was concerned about was, or part of what they were concerned about, is that you have assets in civil law jurisdictions which are subject to common law trusts.
Understand.
And so what you want, they weren't concerned that our courts will recognise them. No. What they were concerned is that if you were trying to sue in, say, Italy, which has become a signatory and successly has recognised this.
I've read the article by Professor Brown.
Exactly. Yeah. That those courts would say, well, we don't know what this is, so go away. That those courts would recognise the common law trust. So that's what you were trying to do. But there was never any question of the common law itself recognising the trust. That was a given. And you'll see that absolutely in the discussion, which is actually in relation to Article 13. And I can pick it up in this volume and then look at Van Overbroek. If you would, in this volume, turn to page 1548.
Yes.
There was a sorry, I need to just to put it in context. Amongst the things that they were discussing was a working document number 33. What working document number 33 was intended to do, and the easiest way to see it in translation, I'm sorry to make you jump around to open a different bundle, but if you open Authorities Volume 1 for a moment and look at page 1043, 1044 rather.
1044.
Yes, at the top of 1044, you'll see in English translation what was called working document number 33. And do you see it says the state parties shall not recognise trusts involving property which at the time of the trust's creation is primarily located in states which do not provide for trusts.
Which paragraph is that?
It's
Top of the second
it's
column.
top of page
third
1044
line.
in Van Overbroek, and he's set out in English working party document number 33. And so what was being said...
We're at 1043.
1044.
1044, I'm
Which
sorry.
paragraph should we be reading?
It's the right-hand column, the first complete paragraph.
The one in italics.
In
So
italics.
this would have been a...
130.
No. Yes, it's part of
Yes,
128.
Sorry, I'm going too quickly. It's part of paragraph 130, and it's the top of the right-hand column.
Right.
And I'm just referring it to you so you can see the translation of working document number 33.
It's part of 128, it's not part of 130.
The columns are in parallel going down.
Right, yes, I see.
Yes.
Anyway, those three lines, line 3 to 5, the second column
no.
of page 104.
Now, the point is, if you read those words as they stand,
Yes?
what the countries who are putting it forward, I think you can see it's France, Greece, and Spain, what the effect of that would be that this court would not recognise a trust, if that had been adopted, which was of assets located in, say, France.
Yes.
And the reason they were concerned about that is they thought there was something mischievous, fraudulent could go on. Now, if you go back to volume 2...
Well, you ought to read halfway down the page.
Yeah, I'm going to come back
Right.
to the Van Overbroek, but I first want
That
to show
proposal
you...
had been accepted, the convention would have achieved nothing whatever.
Exactly.
It would have been counterproductive.
But I want to show you the discussion that preceded this, and that is at volume 2 at 1548.
Which is where we were, yep.
And the relevant part I want to show you is on 1549. 1548 is where they start the discussion.
Right.
But what's interesting is to see at 1549 what Professor Hayton said at the right-hand column foot of the page.
You must be joking.
Where he said that although he had sympathy for the legitimate worries of the civil law countries, he could conceive of practical examples raising serious difficulties. First, with regard to the first half of the proposal, and that's the one that we just looked at, he envisaged the case of a French citizen, owner of a prosperous French company, deciding to emigrate to England, where he there might die, married to an English woman and having English children. The French citizen could have decided to create a testamentary trust, placing the French shares of the French company in trust for the benefit of his wife and children. Mr. Hayton believed that the first half of the proposal would require an English court to refuse to give effect to this trust. The same effect would result if the trusts were inter vivos. He considered such a result unjust with regard to the fair and legitimate trust. And then Mr. Troutman, just below, of the United States, said that although the United States understood the philosophy and would like to cooperate with civil law jurisdictions, he believed the proposal as drafted too broad. It would seem to require the courts in trust jurisdictions to deny effect to trusts that would otherwise be considered valid. And he wanted to make 2 points about that. And he said his second point, first one, he thought there were better ways to identify fraudulent or artificial trusts. Second, he said he was uncertain whether states would find acceptable the broad proposal not to recognise the trust of the type proposed in Mr. Hayton's example. And then Mr. Bennett, in the right-hand column, stated his opinion that this convention had as its topic the recognition of common law trusts within civil law jurisdictions, not otherwise adopting that concept. It had appeared to him earlier that the civil law countries were prepared to recognize the trust on a general basis. That impression was now in great doubt. He understood the concern of civil law countries to be allowed under the convention not to recognize fraudulent trusts, but he agreed with the comments of Messrs. Hayton and Troutman. Although put forward in good faith, this proposal seemed based on a suspicion of the common law trust. He wished to assure that, as a vehicle for fraud, he wished to assure the delegations this wasn't the case. And then he went on to say he also agreed with Mr. Hayton and Mr. Troutman that such a convention would render the common law countries worse off than previously by obliging them to refuse recognition to a number of trusts now frequently recognized, which they would wish to continue to recognize. And that's the whole point. The premise was that the common law recognizes trusts which have been created over assets in a non-trust state. And nobody was going to have a convention which turned that on its head. That would undermine the whole purpose of it. And of course, that's the argument that is being made here. They don't come out expressly and say it. And at 1551, the chairman reverted to this, and he noted in the middle of that paragraph, it's 2/3 of the way down on this, he said, the present proposal would envisage the non-recognition of common law trusts within common law jurisdictions. Quite a different proposal. It would create a rule declaring invalid within common law jurisdictions trusts that would otherwise be valid. Now, Mr. Hapgood and Co.'s argument, whether they put it via Article 4 or Article 15, is precisely that somehow the convention has landed in a situation which has the precisely opposite effect to that which was intended. And the theme is then picked up back in Volume 1 in Van Overbroek. And
what happened? They say at 1551 that a vote on working document 33 was postponed.
It got voted down, and that we can see that.
I like the French comment that was very surprising. She said that a Frenchman should be allowed to create a trust over goods in France.
Yes.
I think it happens.
Well, there is a residual feeling that trusts are somehow underhand because they are unregistered interests, but it's not a peculiarly French eccentricity. Mr. Gladstone's dying words to his son was that he should never mortgage the family estate because mortgage was only another word for fraud.
True words were spoken.
Yeah.
But all this was dealt with by Article 13, wasn't it?
No, sorry, Mark.
All this was dealt with by Article 13.
It's all dealt with by Article 13, which is not part of English law.
No, we've excluded it, yeah.
For the very obvious reason, and we've referred you, I won't take you to it, to the parliamentary debates. The reason it's not part of English law is because it would be a nonsense to have it part
It's
of
irrelevant in England. We recognise the things anyway.
Yeah.
Exactly.
We created them.
But I won't take up more time on this now, the relevant passage in Von Overbroek is at pages, it's worth reading 1043 to 1046, paragraphs 122 to 133, where he explains all of this, and you can see he's referring to this whole background, and the whole premise of this is that in a common law state, one recognises and gives effect to the trust over assets in a non-trust state. And so...
Thank you.
So in our submission, the real purpose of the convention was precisely to provide for the recognition and giving effect in non-trust states of the what's called the Anglo-American trust concept, which didn't exist in those states' domestic laws. And it would really be entirely, we'd say bizarre, but certainly counterintuitive to say that the convention somehow mandates or encourages an English court to decide that a trust can't be created over civil law assets, or that the English court won't give effect to it, which is another way of putting it.
What about 131? Last sentence of that. Doesn't seem to...
Page
1045. The last sentence, maybe it's superseded by the different formulation which became Article 13, but the last three lines...
131.
Yes.
I think it's the argument of the French delegation.
It's just...
Yeah.
Yes,
It's just an
that's the whole point. That was then rejected.
Yes, I see. Yeah.
mean, it was-
Thank you. Yeah. Good.
Curious.
And I've already made the point about the significance of Article 13 and why it's not part of ours. Now, the authorities that my friends rely on for the lex situs rule, we've largely, I mean, you largely have my submissions on why Macmillan, and I think that their two cases are Macmillan and Rangers in reality, and I've explained why Macmillan, we say, is not relevant. The Stichting case and the judgments of, or the observations of Lord Sumption and Lord Toulson at paragraph 15, that the lex situs would generally determine whether the company had a proprietary interest. In my submission, I mean, that's true as far as it goes, but it's not an authority in relation to the issue with which we're considering. I mean, it simply wasn't before the board.
Anyway, you accept the proposition as a general rule. You just say it's a lot more complicated when you're considering arrangements
exactly.
like this.
And there's as I'm sure, no doubt, as the authors, your lordships would think it slightly odd to take that sentence and say, well, you can take that out of context and say, there you are, that provides a rule. Equally, the Glencore case, the decision of in the commercial court of Mr. Justice Morbick, I think as he then was, is all about the transfer of legal title to a tangible, movable, their oil. And in my submission, it simply doesn't tell you anything about the issues with which we're concerned with. I'm going to come to Rangers in a moment, but can I then just make some further observations in relation to Article 4 of the Convention? As the discussion we've already had this morning makes clear, that my submission is it really doesn't get you anywhere, it's an irrelevance, because the whole purpose of the submission that Samba makes is simply to escape the convention. In my submission, they don't escape, but even if they did, it takes them to the common law, and there is no conflicts of law provision which assists them. But I suspect it would be helpful just to understand more fully exactly what Article 4 or what the discussion about Article 4 was doing. Now, it's obvious that where a trust is created by an initial transfer of trust property to the trustee, there won't be a trust unless and until the property has been validly transferred to the trustee. That's just an obvious point. And where you have a declaration, there is no equivalent initial step, because it's all one act. But whichever step you're talking about, whether it's the process of transferring the property or making a declaration, one can see in both circumstances, one, the property must be alienable at all. In other words, you must have a right to dispose of it at all. And secondly, you must have capacity to dispose of it. In other words, if you are an infant, say, then you may not have the legal capacity to dispose of any interest in the property.
So your submission is not founded on any distinction between a declaration of trust and a transfer of assets into a trust?
For those purposes, that those questions are ones, well, that's what was being discussed in the debate about Article 4. It's it was capacity they were particularly concerned about. How does one deal with that where you have a declaration? Now, they didn't actually answer that. What you'll find is there was people saying, well, declarations ought to be within Article 4, but that's what they were concerned about. They ultimately used the words preliminary issues relating to a transfer to a trustee, and they left open this question of capacity. And so it is actually, amongst the academics, a big area of debate as to what law governs capacity. Is it the law of the trust for capacity, or is it some personal law that might apply to the settlor? These are nice questions.
But I mean,
don't arise here.
As I understand it, I mean, obviously Article 4 leaves those questions over to whatever is the law designated by the relevant conflict rules.
But that's an issue that's not before you and not entirely clear.
But I mean, it looks as from the Travo as if lack of capacity was being cited as an important example of one reason why a transaction might be void. But I didn't see anything in the Travo that suggested that that was all that they were concerned with.
The way they put it was formality, capacity, etc.
Well, that's hardly a definitive formulation.
No, it isn't. But what they weren't talking about, it's easy to say what they weren't talking about. What they weren't saying, let's go back a step. If we take the plain vanilla case where you transfer property to the trustee and he's to then hold it for the beneficiaries, no one was saying that in order for the trust to be effective, this must be valid under the lex situs. In other words, that the lex situs of the asset must have within its law the concept of trust, because that would have been totally contrary to the whole purpose of this. So that's the first thing. So when they were talking about declarations and the question as to whether some preliminary issue arises, it wasn't that preliminary issue. It's a preliminary. What they were talking about was things. Well, the only things that we know they were talking about were formality and capacity, and I can't think of anything else which could be a preliminary issue in relation to a declaration which wouldn't be governed by the law of the trust.
I mean, analogies are always misleading, but the suggested analogy between the launcher and the rocket appears to suggest that they were interested in requiring convention states to observe the incidence of a valid trust while leaving outside the convention the question what was a valid trust and whether a particular trust was valid or no.
No, I don't think that's right. What they were talking about, the problem is with the launcher and the rocket, it makes perfect sense where you're talking about transferring the property to the trustee. That is the launch. Thereafter, it's the rocket.
Well, the plainest case, and the only one that's specifically mentioned in Article 4, is the will trust.
Yes.
The will has to be a valid will.
Exactly, and that's because so the will. And that's got nothing to do with the trust. So if I say I'm going to leave my property in trust for the dog's home, and under my personal law, I'm required to leave money to my wife and children. The fact that the trust is governed by English law, which might say there's nothing wrong with that, doesn't get me out of the fact that I'm not able to dispose of my property in that way.
Yes, and then when you get on to other acts, you're looking for some analogy, and of course the first ones that may occur to you may be capacity, formality, it may be illegal as well.
Yes, that's right. But
As it's said to be here, but although that's not an issue for today.
no, exactly. It's, because you've got to remember, because we're at a stage at which there's a dispute which can't be resolved about that.
Yes.
I mean, the nature of the subject matter perhaps could be regarded as a part of the capacity, but certain property is inalienable.
Well, what the Court of Appeal here said, that they were considering the Rangers case, and remember, in Rangers, you remember the facts, and as a matter of Scottish law, the future proceeds don't exist, and therefore you couldn't have a trust. Now, whether actually Scottish law of trusts was relevant at all, we would actually say Lord Hodge made a mistake there. It wasn't. But you can understand the conclusion in that you can't have a trust, any trust, over property which doesn't exist.
Well, you can, in English law, in certain circumstances, Tailby and the official receiver appears to decide that. You can have a trust over future property which attaches to the property as and when it does start existing.
Yes, but if if the position is that Rangers, which is a football club in Scotland, doesn't presently, as a matter of Scottish law, actually have any property, then one could see, well, the question of whether a trust was created when they don't presently possess property
Falls away. I mean, I think that's the argument, in a sense, against you, which Mr. Hapgood is relying on this case for. That if, under the relevant law, which in Rangers was Scottish law, the relevant property doesn't or can't exist, then questions about whether it can validly be transferred or created by agreement simply don't arise.
Well, what we would accept is what the Court of Appeal said, which is if all that one is saying is that the property is not alienable at all.
Why should it be confined to alienability?
Well,
there may be a number of reasons why the relevant interest can't exist under the relevant law.
Well, the way your Lordship has put it begs the question, what is the relevant law?
Of course.
And that's the whole point. Under the trust, the relevant law is the law of the trust. So you can have, if the trust recognises future property, there's absolutely no reason why that should be a problem. But if you don't actually possess any property in the first place, then it's easier to understand why you couldn't create or to say that you can't have a trust, because it's just an impossibility. The property doesn't exist.
In Rangers, the relevant law of the so-called trust was English law.
It was, yes.
Yes.
That's where we.
But Scottish law determined what kind of interest could exist.
Well, we say that Rangers, Lord Hodge went wrong insofar as he was actually asking himself what the Scottish law of trust was.
You said he got the Scottish law of trust wrong.
Whether he got it wrong or right, it's just an irrelevant point. Because it's a convention country, so he was obliged to apply the conflicts of rules provisions in the convention. I mean, it wasn't even a declaration case. He treated it as a declaration, but there wasn't a declaration in the form in which we would understand it. I mean, ultimately,
you say he went contrary to those passages in the Travo, effectively, because the reasoning was, under Scots law, this is something we don't recognise as a property interest, and therefore it can't be the valid subject of an English trust, which is the exact contrary of those passages you were showing us.
And the way in which the academics had approached it, and as the Court of Appeal recite, both Professor Harris and Professor Hayton had sought to justify the decision by saying, well, if property can't be alienated at all, then one could see that you couldn't put it in trust. I mean, for instance, what the example that I think Professor Harris gives, which is, let's say you have some property in a foreign jurisdiction, and under the law of that jurisdiction, you are prohibited from alienating it at all. Professor Harris says, well, it would be rather odd if what you do is you declare yourself as a trustee of it, and then the beneficiaries can call for the property. Now, one reason that that analysis may not actually be right is that the beneficiaries may not be able to call for it if the property can't be transferred to them. But Professor Harris and the Court of Appeal accepted this, was saying, and it appears in Underhill and Hayton, one of the things one needs to be a bit careful about is working out whether who it is who's written these things. So sometimes when you read them, you think this all looks rather similar to what was under Professor Harris's name, and it is in fact Professor Harris again. So there's a note of caution when reading the textbook. But the point that the Court of Appeal accepted was that if the property is simply inalienable, then it's not at all surprising to say you can't have a trust over it.
But Lord Hodge wasn't, as I read him, saying that English law can't create a trust. He was simply identifying the limits beyond which Scottish law would not give effect to such a trust. So I'm not sure it was the same issue as the one that featured in the discussion of Article 13 that you pointed us to. What he was saying is that English law can do this, but Scottish law will not recognise that in relation to an interest which it does not regard as capable of existing. Because the assets are located here.
Yes.
In Scotland, that is to say.
In Scotland. Now,
It doesn't exist in English law either.
it's... I would suggest if the case had been litigated in the English court...
in relation to an English asset?
No, in relation to the Scottish asset, that the English court might well have reached a different conclusion because the English court would have said that we do recognise this species of property and it is possible to create, at least arguably, to create a trust, because the trust is actually in English law not over the future property. You have an equitable right to it, and the trust comes into being when you receive the instalments of the season ticket monies or whatever it was. So it's
English law would say the trust attaches to property as and when it comes into being.
exactly.
And Scottish law, if Lord Hodge got Scottish law right, and evidence had been given to that effect of Scottish law in the English proceedings, the argument would be that the English court would be bound to have regard to what species of property is capable of existing under the law of the place where this property is located.
That's essentially the point, that if as a matter of Scottish law, if in fact that Rangers didn't as a matter of Scottish law own anything to put it in trust, then what the Court of Appeal was saying, well, it's just impossible to create a trust over an asset which is in Scotland, which you don't actually, well, it's not there. It's just there is nothing. You can't have a trust over something that isn't there.
Which is what's said against you here.
I'm sorry, Mort?
Which is what's said against you here.
It's not said against me here that the asset doesn't exist. Nor is it said that it's not said that the asset is inalienable under Saudi law. All that's said against me is what would be said. One's got to remember what is said against us is what would be said in any civil law jurisdiction, which is any trust which is a common law trust over an asset in a civil law jurisdiction, whose law doesn't have a separation of legal and equitable interests. The argument would be the same, that the common law trust fails. So all of the cases that we were looking at necessarily were proceeding on a false premise. And equally, the discussion in the convention, in the Travaux, was proceeding on a false premise of the common law recognising trusts over assets in civil law states.
The argument in the Rangers case was whether the administrators were entitled, albeit in breach of contract with Ticketus, to terminate the arrangements with Ticketus. So the case proceeded on the basis that the arrangements gave rise to at least contractual rights, and the question whether those rights could be terminated, albeit it would involve a breach of contract by the administrators, depended upon whether they also gave some sort of proprietary rights. Exactly. I think so. It's a slightly, it's a difficult situation because we do say that for your purposes, the nature of the contractual rights recognised by under the English trust is quite sufficient in terms of the Insolvency Act.
Yes.
Well, I think surely the problem in Rangers was not that there was a breach of the contract. The contractual obligations automatically came to an end upon the commencement of the winding up and were transformed into rights to claim the value of the relevant contractual obligations against the insolvent estate. So there was no question of breaking the contract.
You get a dividend.
But, of course, if there was a proprietary right, then that would be outside the insolvent estate altogether.
Yeah.
Well, that's not the way it's put, actually. If you look at paragraph 9, the direction sought was as to whether they can be prevented from causing Rangers to terminate or be it in breach of their terms, the Ticketus agreements. There hadn't been a winding up, had there? It was just an administration.
Yeah,
Administration.
that's right. That's quite right.
Yes. But I mean, ultimately, the issue was what was the nature of the legal right that
Right.
Ticketus had, and what, I mean, it's what his lordship found was that, I mean, with respect, the judgment is slightly confused on both on how you get there, both via Article 4 and what he's saying about Article 15. But ultimately, I mean, what he says at 24, I'm therefore persuaded that the recognition of Trust Act does not have the effect of making the law chosen by the settlor the governing law of the steps needed to create the trust. Were it otherwise, the result would be startling, as a settlor would be able to alienate property which he could not dispose of under the lex situs. Now, if what is being said is, well, and that's what the Court of Appeal was saying, well, if the property is inalienable under the lex situs, in other words, that's not something which is for the law of the trust. The law of the trust can't override some prohibition that you have under the lex situs, which prevents you alienating your property. Now, and that, if one goes, perhaps, if we could just go to the Court of Appeal for a moment to look at what they said about this.
Yep, paragraph.
They start, the Court of Appeals start at 40,
Thank you.
where they mention, they deal with Rangers. And at 41, they quote from paragraph 24. Then at 42, they refer to the commentators. And then they correctly say in the last sentence that it's important to understand precisely what the commentators are saying is excluded by Article 4. And at 43, they refer to Professor Hayton's article from 1987, which Mr. Hapgood took you to, which is, in fact, this is the only reference in any of this material where anybody has suggested what he says here. But and at 44, they refer to the 18th edition of Underhill and Hayton, where they made the point, and I think this may be Professor Harris actually, but it features in the later edition as well. One could argue that two questions arise as to the passing of property: the transfer of legal title, the transfer of equitable title. However, civil law systems know nothing of equitable title, and once legal title has been validly transferred to B, the rocket launching process is concluded. It follows the sole question with which the lex situs should concern itself is whether legal title to an interest may be alienated. It should not be a reason to invalidate the rocket launching process that the situs does not know the trust concept. The particular interest which the beneficiary acquires under the trust should be seen as an aspect of the relationship between trustee and beneficiary, and governed by the applicable law of the trust, as determined by the rules of the Hague Convention. In a common law country, a beneficiary will obtain an equitable proprietary interest binding third parties, but in a civil law country, not knowing such a proprietary interest, a beneficiary will only obtain a ring-fenced interest binding the trustees, creditors and heirs, but not third parties. And of course, when he talks about a civil law country, he's talking about if you're in the courts of a civil law country, what it would do. And then they refer to Professor Hayton's views on the Rangers case, where he says, and so you can see that Professor Harris and Professor Hayton are ad idem on this, whether the settlor has capacity to alienate the property at all must be distinguished from capacity to create the trust structure. However, in Rangers, where an English lender made a loan to a Scots football club in an agreement governed by English law with future season ticket monies, paid by the club's supporters to be held as soon as received for repaying the lender, the Scots court held that the Scots club had no capacity to alienate future Scots assets, the Scots lex situs governing the non-assignability of Scots' future property. In the case of a settlor declaring himself sole trustee of designated property of his, seems if he has full power to alienate such property, he should be able unilaterally to declare himself such a trustee if the applicable law of the trust allows this. The Italian courts have recognised such unilateral declarations of trust under a foreign trust law governing Italian movables, and the Quebec courts have recognised a unilateral declaration under California law, the Quebec immovable. Thus it appears that Professor Hayton would say Rangers was correctly decided, that under Scottish law it was not possible to alienate future receipts at all, so that the club's capacity to do so was governed by the lex situs under Article 4. In a supplemental written submission after the hearing, Samba submitted that Professor Hayton was wrong on this, and that Lord Hodge had actually decided that Scottish law as the lex situs governed the validity of the declaration of trust, which failed because under Scottish law it was impossible to create a trust. Then they refer to Professor Harris, who draws a clear distinction between capacity to alienate property governed by the lex situs, capacity to create the trust governed by the trust structure. And they refer to launching the rocket, the capacity and creation of inter vivos transnational trusts. There will then be a second question as to whether the settlor who has capacity to alienate property, according to the lex situs, has capacity to create the trust structure with that property. The interest of the lex situs can sensibly be confined to the question whether the settlor can dispose of his property at all. Once he can do so, once he's able to do so, it should not be that law's concern whether he makes an outright transfer of the property or transfers on trust. The restrictions upon a settlor seem legitimately targeted at the question whether he may dispose of property at all, not whether he may dispose of it on trust. And they
Why should capacity be any different from any other reason which shows that under the lex situs the creation of the relevant interest is impossible? I mean, capacity is one reason why that may be so, but it may also be that there simply is not an interest of the relevant kind, simply doesn't exist under the lex situs. They are all examples of legal impossibility.
well,
What is the distinction between legal impossibility on grounds of capacity and on other grounds?
the point is that you have to remember what you're trying to do with a common law trust over an asset, say, in Saudi Arabia, is to create rights here under Cayman Islands law. You're not seeking to create rights under Saudi Arabian law.
But that would apply equally to, that would mean that Lord Hodge was wrong. I mean, it seems very odd that you accept that if the property can't exist, the way he puts it in paragraph 24 is by analogy, startling if a settler would be able to alienate property which he cannot dispose of, could not dispose of, under the lex situs. That's what he says in the second sentence, paragraph 24. It's a bit odd if something even more fundamental, the property isn't regarded as existing under lex situs, can't exist. It seems a more fundamental objection to the creation of a trust than saying it exists, but you can't transfer it.
Well, exactly the same position pertains under English law. If property doesn't exist, you couldn't have a trust over it. And so insofar as there was a difference, here you had a question of whether, as a matter of English law, the property existed, as opposed to a matter of Scottish law. Now, bearing in mind Rangers, this is being decided in an insolvency context with Rangers in Scotland. The question is, it actually comes down to a question of capacity. As a matter of Scottish law, what his lordship is saying is Rangers didn't have the capacity to alienate future property because, as a matter of Scottish law, that property at that stage didn't exist. Yeah. And so it could not alienate it at all.
Well, that's not really a question of capacity.
No, it's not. It's not a capacity question properly so called, as we all understand capacity, but it is
it's
capacity.
Inherent in the property and not in the transferor.
Exactly.
Sorry, I didn't catch
the problem is inherent in the property.
In the nature
nature of the property and not in the character of the transferor.
Exactly. It's the nature of the property but the transferor is a Scottish company, and it doesn't actually, at the date of the trust, have any property to put into trust. The property just didn't exist as a matter of Scottish law, and so
exactly.
It's all that is then being said is, well, if it doesn't exist, you couldn't have perfected a trust over something that didn't exist. And it doesn't matter the trust is governed by a foreign law.
Well, the real point was it was incapable of existing.
Exactly.
Because in English law, you can create a trust over non-existent property if it's going to exist in future. But obviously you can't create trust over property which is never going to exist because it's inherently incapable of existing.
Yes, we would say that where one is talking about future property, that as a matter of English law, there wouldn't in fact be a trust at all. There would be a right in equity, which would be a right which would, I think as your lordship was saying before,
there would be a trust which would attach to the asset by virtue of the trust deed as and when it came into existence.
But there isn't actually a present trust until the asset comes into existence.
It seems a rather theological point.
Yes.
Well, but for our purposes in our submission, it doesn't really matter in that for what we're debating, remember, we're debating a completely different question. That's why I have to keep bringing everybody back to what the point is in this case. The point in this case is actually a much narrower one. It's simply saying, the only issue before you is the premise is that in Saudi Arabia there is no concept of trusts. There's no, the way it's put in the statement of facts, and it's the basis on which we're all proceeding, there's no means under Saudi Arabian law, and those are the critical words, of creating separate legal and equitable proprietary interests. And so the
Because
question...
they don't recognise the concept of of multiple rights in the same...
They're the same as the countries, the civil law countries that were party to the Travaux, that don't have this concept. The same as Italy, in fact, who has signed up to the convention, but has seen that that isn't an impediment to recognising and giving effect to the trust. And so Rangers is not actually about, in my submission, about an analogous situation. It's about a situation where, as a matter of Scottish law, something just didn't exist and wasn't therefore alienable at all under the Lex Citus. And that's how the Court of Appeal approached it. I mean, if one looks at paragraph 50 of the Court of Appeal's judgment, what the Court of Appeal actually is saying, the debate had nothing to do with Article 4. So what the Court of Appeal said, that this debate, that they look at paragraph 50 as, they look at Article 50, they look at Article 4, and they conclude in that paragraph that Article 4 is construed as meaning what it says, namely it's concerned with preliminary issues relating to acts by virtue of which assets are transferred to the trustee. And they say the declarations of trust don't transfer anything to the trustee. And then at 51, what they're saying is that they have no difficulty accepting the dictum of Lord Hodge, as explained by Hayden and Harris, when they opine that the Lex Citus must govern whether the trustee has the capacity to alienate the property at all. It would, as they say, make no sense to hold that a trust be created by a person who owned inalienable property. But once in our judgment, once it's clear the trust property can be alienated in some form, according to the Lex Citus, that law cannot govern the trust or its validity or effects. And so, as I read them, what they are saying is it's not really a question that arises by virtue of Article 4. It's simply something that arises in consequence of the fact that you're trying to create a trust over an asset in a foreign jurisdiction. And if the Lex Citus says that asset can't be alienated at all, quite an unusual thing to think about, because most assets are going to be capable of being alienated, then that could prevent the trust, because you would have to take account of that. But short of that, the Lex Citus has got nothing to do with it, is what they're saying, and in my submission, they're right. And 52, you can see that must be so, because they say that the declarations of trust are not acts by which virtue of which assets are transferred to the trustee. And at 53, they explain why Millen, in their view, doesn't apply. And then at 54, explain why the Chancellor was addressing the wrong question in relation to Macmillan. And at 56, they explained that since the Lex Citus only governs the transfer of assets to the trustee, and the 6 transactions either validly transferred some of the shares to Mr. Al-Sania under Saudi law or left others in the shares in his name, not necessary for us to consider other rules of Saudi Arabian law. The rule about foreigners not being able to own shares, the need for registration of shares, don't deprive Mr. Al-Sania of the right to alienate the shares at all. They cannot therefore invalidate the trust by virtue of Article 4. And the paragraph that's being criticised, paragraph 55, the end of it, what you can see they're actually talking about is the second stage. So they refer to Glencore and then say these are powerful observations, but they say we don't think they impact on what has to be decided here, provided that the property is made subject of a trust can be alienated at all under the lex situs. Questions as to the validity and effect of placing assets in trust, even though their shares in a civil jurisdiction, can be determined by the governing law of the trust. Put the matter in the context of this case, the declarations of trust will not be dividing the equitable and legal interests under Saudi law, and that's the important thing. That's not possible. But they may give sickle rights under the trust in respect of those shares, which will have to be determined by the governing law of the trust. Now, the next part, where they say taking into account that under Saudi Arabian law, a division of equitable and legal interest is not possible, all these matters will have to be worked out at the next stage of the litigation, when the court comes to consider the effect on the rights granted by the declaration of trust of the transfer to Samba, which took effect. What they're there talking about is what happens when the debate takes place about validation. So at that stage, the court will have to consider what the relevance is of the fact that they got, if they did, good title under Saudi law.
Is that a convenient moment?
It is.
Thank you very much. 2 o'clock, court's now adjourned.